Okay, good morning, Rhonda. I think we have Mr. Smead here. Are you going to need a breakout session with him?
Just very briefly, Your Honor.
All right, Mr. Smead, are you able to hear me?
Yep, I had to join the audio.
Okay. Okay, I'm going to put you in a breakout session with Ms. Underwood so you can speak to her privately.
Okay.
Okay, good morning. For the person at the MDOC facility, can you tell me your name?
Joshua Falls.
Okay, Mr. Folds, your attorney is with another client right now. I'm going to put you back in the waiting room, and as soon as she is available, have you to speak with her.
All right.
The iPad. Okay, we are on the record now in files 23-21455-FH and 23-21456-FH, People versus Matthew Eric Edward Smead. We are here today for pretrial conferences in both of those cases. We are proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. Berta.
Yes, Your Honor. Christy Berta from the AG's office, appearing for the people on both files.
Rhonda Underwood appearing for Mr. Smead, Your Honor.
All right, and Ms. Underwood, where do we stand with Mr. Smead's cases today?
As I understand, Your Honor, both from the AG's office and from Mr. Smead, Mr. Smead is making payments. They aren't quite enough. They would like larger payment. I've explained that to Mr. Smead, but he is making a real effort, Your Honor. So we are going to ask for a 60-day adjournment for further payments, Your Honor. And I don't believe the AG's office would have any objection to that.
Your Honor, I'll leave that to the court's discretion. There is an income withholding order on both files, as well as a third file, which muddies the water a bit in terms of his weekly payments. but I'll leave that to the court's discretion regarding an adjournment.
What's the difference in the payments? Is he
Well-
reducing the average at this point, or?
I wouldn't say it's necessarily being reduced, Your Honor, because he's not paying enough to pay on each file. So although he's making genuine efforts to make payments and there is a withholding order in place, it's not covering what is owed on each file.
So the arrearage is increasing?
I would say so, Your Honor.
Can I say something?
I don't know whether your attorney wants you to do that, Mr. Smead. If you say something, it can be used against you.
At this point, I'm like at my wit's end with this stuff, because I pay all this money. I don't get to see my kids. I have
All right,
job off.
Mr. Smead, I'm gonna cut you off because we're not here about parenting time. I don't know what the issue is with your ability to see your children. This is
But no.
simply about the payment of support.
Right.
Or in this
And
case, the non-payment of support. Mr. Smead, please don't interrupt me, all right? You are represented by an attorney, and we're not gonna get into those other issues.
No, I was getting to this case.
No, Mr. Smead,
Mr. Smead, you are represented by an attorney at this point, and she does not, I don't believe, want you to speak, because anything you say in this court hearing can be used against you if we eventually have a trial.
And what I'm about to say, I've already told her.
There's a difference between telling your attorney, who has to keep that in confidence, and telling the court in an open public record. So what I'm going to do is I will adjourn this 30 days. If the arrearages are still going up at that time, we will set it for a trial.
Okay, well, they're still going to go up because as long as I'm in
Mr.
court, I
Smead,
can't.
please stop talking. I'm trying to do this as a favor to you. You're going to get yourself in trouble by saying something on the record that can be used against you later if you keep talking.
Can I please say something?
Mr. Smead,
I need to say what I already told you.
Mr. Smead, please do not say anything. Call my office and make an appointment.
Fall further behind.
Mr.
I'm going to end up in prison, and that's going to be the end of it.
Mr. Smead, please.
Guys, please don't.
I'll set this for, all right, I'm going to mute Mr. Smead's device because he is being disruptive and not allowing us to conduct this pretrial in a business-like manner. So we will set this for a pretrial on May 15th at 8:15 a.m.
May 16th, Your Honor,
15th.
15th, and I will prepare the stipulation in order with Ms. Berta's permission, Your Honor.
Of course, Ms. Underwood.
All right, Mr. Smead, you need to log back in next on May 15th at 8:15 a.m. Mr. Smead, you're muted. I can see you're talking, but we can't hear you because I've muted you. You were being disrupted. So log back in next time on May 15th at 8:15 a.m. I'm going to remove you from the meeting now. Okay, and Ms. Underwood and Ms. Bird, I think we also had Monica Petty was a, oh, I'm sorry, that's not an agent case. Ms. Bird, was that the only one you had today?
I think that's the only two that I had with you, and I think I have to go to Judge Anzalone's.
I'll be over in a few minutes, Ms. Berta.
That's fine. Thank you, Your Honor.
All right, thank you. And so Ms. Underwood, we have Joshua Folds here from MDOC.
Thank you, Your Honor. if I could have just a brief breakout with him.
Yeah, as
Continue
soon
the
as I figure out
conversation.
where, okay, there he is. All right, Mr. Foltz, I'm gonna put you in a breakout session with Ms. Underwood.
all right.
And Mr. Glazier, we have Mr. Parcell here in the courtroom. Are you gonna need to speak to him? You're muted, Mr. Glazier.
Is Phoebe logged in?
I believe she is here somewhere, yes.
Yeah,
I'm here.
This is the guy that we did the CCW class and he filled out the application. I should have sent it to you. I think I sent it to you.
Yeah, I don't know that I got anything from you on this one. That this is, you're correct, and that's what we were gonna do, but I don't think I got any.
He did it. I'm pretty sure I mailed it to you, but
I have everything right here.
Oh, that's right, and I actually did fill out an Oli Pros. Maybe it didn't get to the court though.
okay.
I can forward that right now if the court doesn't have a copy.
Let me look. I don't know if I've seen it or not. I'll just check the ROA and see if there's anything there.
Okay.
Apparently, the website is not cooperating with me today, so if you want to send it over, we'll make sure it's signed one way or another.
Okay.
All right.
Is there anything else we need to do with this case then?
Now, if you just let Mr. Purcell know that the dismissal is being filed.
Okay. So, Mr. Parcell, we're gonna, if a dismissal of your case hasn't been filed already, it'll get filed today. So you're all set.
Okay, so, the paperwork that I need to submit the application, for the CCW, because I'm not able to submit the application because of the pending felony.
I'm sorry, so can you come up to the table?
Yeah, yeah,
so that we
absolutely.
can. I'm sorry, so what was your question?
Okay, so, in order for me to submit this application, to get the to get the CCW.
Yeah.
License, what do I need to give them in the office, because there's a pending felony, and, without, further due to that, I'm not gonna be able to submit the
So
application.
there's a document that I'm gonna sign, that if I haven't signed already, I'm gonna sign as soon as I get a copy of it. And that is,
I was
I'm
just
sorry.
gonna say, Mr. Parcell, on your application, just indicate there is no pending felony now, because now when they look it up, it'll show it as dismissed. Within, I would say 24 to 48 hours anyway.
Okay, so I should wait a day or two before I file the application?
Yeah, and just mark on your application, no pending felonies.
Okay.
okay, so I just signed the dismissal and placed that in file. It'll get processed through the clerk's office today.
Okay, do I need to see anybody in the office, or?
If you want a copy of that, you can, if you want to wait for about 3 minutes, we'll get you a copy of it.
Okay, I'll wait right
Across the
outside.
hallway there.
Okay.
Right.
All right,
All right, so you are all set.
all right, thank you guys, have a good day.
That's all I have with you this morning. Thank you, Your Honor.
Okay, thank you, Mr. Glazier. Okay. And jail for-
Hello, Your Honor. It's Tyler with DRC Video Support. Can you hear me all right?
Yeah, I'm sorry. Who was that?
Alrighty, this is Tyler with DRC Video Support. I'm here with North Central. It looks like they're still waiting on the inmate to show up to the room. It should be another couple minutes. Alrighty. Thank you.
Okay, thanks. All right, Ms. Underwood, are you ready to proceed with Mr. Folds?
I am, Your Honor. Thank you.
Okay, so we're on the record in file 23-21481-FH, People versus Joshua Dwayne Folds. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Arnold for the People.
Allison Arnold for the People.
Rhonda Underwood for Mr. Folds this morning, Your Honor.
All right, and Ms. Underwood, where do we stand with Mr. Folds' case today?
Mr. Folds and I.
All right, Mr. Folds, just give us a minute. I just want to understand from Ms. Underwood what the status of your case is.
Mr. Folds and I have
I want
just.
to know who David Goldstein is right there. Is that a person that's on my
Mr.
case?
Folds, Mr. Folds, he's another attorney that has nothing to do with this case. So just please remain quiet and let Ms. Underwood tell me what the status of your case is.
Thank you. Your Honor, Mr. Folds and I are discussing very seriously questions, and I'm answering them regarding the prosecution's offer. I believe that's productive. I would ask for a 30 to 45 day adjournment to either resolve this matter or put it on the trial schedule, Your Honor.
Ms. Arnold, is there anything you'd like to say from the people's perspective?
No, Your Honor, we're fine with an adjournment.
She can come try to talk to me if she wants to. I've had the whole night to sleep.
All right, Ms. Hennigan, please mute your device. All right, so the case is 243 days since it was bound over. We've had plenty of time to answer questions and try to reach a plea at this point. So I'm going to set it for trial. And if you can reach an agreement in the meantime, then terrific. But I can't just let this continue to be adjourned. How long, Ms. Arnold, do you think you need for a trial?
2 days, I would say.
Ms. Underwood, do you think 2 days is sufficient?
That would seem generous, Your Honor. Yeah, that's fine.
All right, Ms. Clark, can you find us a 2-day jury trial date?
August 13th at 9 a.m. and August 14th at 10:30.
Let me just check Mr. Sneed's schedule. That looks like the 13th and 14th looks like it'll work.
That's fine.
All right, so let's do a final pretrial then on August 7th and trial on August 13th and 14th. If you reach a resolution and want to put a plea on before that, you're welcome to contact the court and schedule a Wednesday morning to do that. All right, Mr. Folds, you are all set. You can let the officer with you know that you are done with court for today.
All right, thank you, Your Honor.
Thank you.
It was my pleasure.
Your Honor, do we have Ms. Petty?
We do not. She contacted the office. Yes. Oh, I'm sorry. You are Ms. Petty. Okay, you can come forward and sit right here. She is here. Do you need to speak to her first, or do you need? Are you ready? Ms. Underwood, do you need to speak to Ms. Petty?
No, I do not, Your Honor.
All right, we are on the record in file 23-21571-FH People versus Monica Lee Petty. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Rhonda Underwood for Ms. Petty this morning, Your Honor.
All right, and Ms. Underwood, where do we stand with Ms. Petty's case today?
Your Honor, I've spoken with Mr. Wendt, and Ms. Petty is doing a wonderful job in making payments in this matter, Your Honor. I believe it was my impression from Mr. Wendt that she needs one more adjournment to complete this matter, Your Honor. And we would ask for 60 days to give her the opportunity to complete payments in this matter. She has really stepped it up and been productive.
All right, Ms. Arnold, anything from the people's side?
No, Your Honor, we're fine with that.
60 days would take us to June. Let's do June 5th at 8:15.
Thank you, Your Honor. And I will do the stipulation and adjournment with Ms. Arnold's permission.
Yep, that's fine. Was it this June 16th?
I thought he said
June 5th. June
Oh, I'm
5.
sorry. Thanks, Judge.
So Ms. Petty, your next date is June 5th. You can either come in person as you did today, or you can attend by Zoom if you prefer. The bailiff can give you our Zoom information.
All right, thank you.
Yep, thank you. Okay, Ms. Hennigan, we have Mr. Scroggins here. Do you need a breakout session with him?
No, Your Honor, I should not need a breakout session.
Okay, we are on the record in file 23-21415-FH, 23-21416-FC, 23-21417-FH, and 24-21675-FH. People versus Levi Scroggins. We are here today for a final pretrial conference in the 23-21416-FC file and pretrial conferences in all of the other files. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Mayor Hennigan on behalf of Mr. Scroggins.
Right, so it's final pretrial in the FC case. Where do we stand today, Ms. Hennigan?
Your Honor, I've had opportunity to review the plea offer that was sent to me by Ms. Arnold, and I've had the opportunity to speak with my client about it in detail. I would note that my client does not want to accept the plea offer and would like to go forward to trial. I also note that my client has asked me to make a motion with this court for a change of venue. I've indicated to him that I would orally request that on the record today. I have also notified Ms. Arnold that my client would be requesting this as my client's position that the court and the prosecutor's office are not able to be biased in his case and are prejudiced against him. I hope I'm explaining it correctly, as Mr. Scroggins has asked me to. He very much so feels that the prosecutor's office already has their mind made up towards him, and that it is impacting the prosecution of his case and possibly impacted his previous mistrial. And so he's asked me to officially make that motion to the court, and I'm doing that on his behalf this morning. Thank you, Your Honor.
As well as violating my rights.
I'm sorry. Yes, Your Honor. And as well as Mr. Scroggins feels that his due process rights were not honored during the issuance of these charges, and he wants that noted for the record as well, and for me to make that notation on his behalf as well, Your Honor.
It's already been placed on the record.
Yes. Thank you, Mr. Scroggins, for reminding the court of that.
All right, Ms. Arnold, do you care to respond?
I'll just state briefly that we have made a plea offer for Mr. Scroggins that's significantly below the guidelines on the carjacking case, which started 9 years and go up to 30 years with the habitual offender supplements. He also has other files. There may be a possibility of some consecutive sentencing. We've been more than fair with him, and we don't originate the charges. They come from law enforcement to us. We just review them for legal accuracy. I don't think there's been any appropriate legal basis stated on the record to change venue in this matter.
Right, with respect to the motion to change venue, a criminal case can be, venue in a criminal case can be changed upon good cause shown by either party. I don't believe in this case that there has been any good cause shown for changing venue to another county. There's no indication that a potential jury pool in this case has any knowledge whatsoever about this incident, and we were able to pick a fair and impartial jury during the first attempt at this trial, which resulted in a mistrial. So I don't think there's any basis for a motion for change of venue. With respect to the request that I disqualify myself from this case, I'm going to deny that request as well. The motion has not outlined any of the reasons under the court rule or case law as to why I would be required to disqualify myself from this case. And I don't feel that I have any bias or prejudice against Mr. Scroggins, and am capable of conducting trial in a fair manner. With respect to the due process rights, the motion at this point has simply a claim that the due process rights have been violated without an articulation of how that occurred, and so I'm going to deny the motion back to the due process rights issue as well. Do we have any issues that we need to address regarding the jury instructions in this case?
Judge, we've submitted jury instructions and a jury verdict form. I don't believe they would be objectionable to the defense, but if we haven't heard, I don't believe the defense has stipulated or submitted an alternative set.
Your Honor, I do have a copy of those jury instructions, and Miss Arnold, are the same instructions from the last trial, correct?
The last trial was not the carjacking case, so they were previously submitted.
Understood. I will review those again today. If I have any objection, I'll get right over to you, but I have reviewed them once before, and I did not see any reason to object based on the statutory basis of the charges.
Yeah, Judge, I think the only thing that might confuse some people is the fact that carjacking and UDAA are not, it's not double jeopardy to convict somebody of both. So they're not instructed in the alternative. The jury actually gets instructed on both offenses and could come back not guilty on both, guilty on one or the other, or guilty of both.
May I say something?
Right. If there are any issues, Mr. Scroggins, you are represented by an attorney, and she will speak for you during this hearing. If there are any issues with respect to jury instructions or voir dire questions, I would just ask that you bring them to me as quickly as possible so that we can resolve them sometime before the trial begins on April 23rd at 9 a.m.
Thank you, Your Honor. I would note that I'm certain that Mr. Scroggins would want me to also place on the record that it is his position that the carjacking and the UDAA would be double jeopardy. We have discussed this in our meetings. However, it is my obligation to the court to notice the court of my client's position. So I would like the court to take note of that so that Mr. Scroggins' appellate rights are preserved if needed in the future.
All right, you have created a record of that.
Thank you, Your Honor.
Is there anything else we need to address with any of these cases today?
No, thank you, Your Honor.
No, Your Honor, thank you for considering my client's request this morning. I appreciate the court's time. Thank you, Ms. Arnold.
Thanks.
Our next date is April 23rd. With respect to all of the other files, we'll just set them for pretrial on the same date of April 23rd. Just so we have a date on the calendar for those. It will be a trial date with respect to the 23-21416-FC file.
Thank you, Your Honor. Would you like me to prepare notice to adjourn the additional cases for pretrial?
If you would do that, I would appreciate it very much. Thank you.
And you can sign my name, of course.
Thank you, Ms. Arnold.
Thanks.
May I speak with my attorney?
Yes. Mr. Goldstein, we have Mr. Crone here. Do you need a breakout session with him? And the gentleman at the Ohio facility, are you Mr. Powers?
Yes, sir.
Okay, Mr. Linton, do you need to speak to Mr. Powers in a breakout session?
No, we're ready to proceed if the court is.
Okay. Okay, we're on the record in file 22-21173-FH, People versus David Eugene Powers. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Mr. Bayoneto.
Morning, Your Honor. Alex Bayoneto for the people.
And Mark Linton on behalf of the defendant.
All right, Mr. Linton, where do we stand with Mr. Powers' case today?
As you know, last time, Your Honor, we had asked for a Cobb's evaluation and communicating with Mr. Bayoneto, we would agree that the sentencing guidelines would fall 0 to 11 months. So what we'd be doing was be a plea to 2 misdemeanors, one of malicious destruction of property and second of attempted fleeing and eluding 4th degree. I know that Mr. Powers was detained for, Mr. Powers, was it 5 months before you were transferred on this case? Oh, you're muted.
Sorry, there was some background noise, so I muted his device.
Can you unmute Mr. Powers? I don't know why it's not unmuting. Well, I believe it was 5 months he was held on this case and then transferred down to Ohio. Since I think October, he's then been held in Ohio. He was eligible for release, but they held him because of this case pending. So I think there's a possibility that his sentence or his amount of time he's already been detained on this case would be very close to, if not exceeding, the guidelines of 0 to 11 months.
So the plea agreement is that he's going to plead to 2 misdemeanors?
Correct.
Your Honor, you should have an amended information on this. I did send that in this morning. It would add an added count 6 of attempted fleeing and eluding and added count 5 of attempted fleeing and eluding and an added count 6 of malicious destruction of property 200 to 1,000.
Okay. Yeah, I do have that. So, Mr. Powers, would you raise your right hand, please?
Oh. Your Honor, I did forget to put it was going to be a no contest plea. I apologize.
Okay. And what's the reason for the no contest plea?
Lack of memory.
Okay. All right, Mr. Powers, you can raise your right hand again then. Sir, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do. Yes, sir.
And you are David Eugene Powers?
Yes, sir.
Mr. Powers, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest today to count 5 attempted fleeing and eluding a police officer 4th degree?
Yes, sir.
You understand the maximum possible penalty for that offense is up to 2 years in prison?
Yes, sir.
And is it also your intention to plead guilty to count 6, malicious destruction of property?
Yes, sir.
I'm sorry, that's $200 or more, but less than $1,000. And you understand that that is a misdemeanor with the maximum possible punishment of 1 year in jail?
Yes, sir.
Your Honor, I apologize for the interruption. I don't know if this was placed on the record. There is a known restitution amount of, I believe it's $3,518.35 that we were requesting as part of the plea deal.
That's fine.
All right, Mr. Powers, are you satisfied with your attorney and the advice that he's given?
Yes, sir.
Do you understand that, let's see, I went over the maximums. So neither prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that accurate? Other than as we discussed on the record here today, is that accurate, Mr. Vanetto?
Yes, Your Honor.
Mr. Linton?
Yes, Your Honor.
Is that also your understanding, Mr. Powers?
Yes, sir. Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you will be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and do not have to prove anything. You have the right to be present at your trial and have the witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Powers, that if your plea is accepted, you may have the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States of America, a conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
And do you understand that you are giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about June 6, 2021 in Dover Township, Lenawee County, Michigan, that you did commit the offense of attempted fleeing and eluding a police officer, 4th degree?
Mr. Powers, just to be clear, you're pleading no contest. Means
Yes, no contest, Your Honor.
And how do you wish to plead to the charge that on or about June 6, 2021 in Dover Township, Lenawee County, Michigan, that you did commit the offense of malicious destruction of personal property, $200 or more, but less than $1,000?
No contest.
Do you understand that if I accept your plea, I'm sorry, has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No, sir.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that the pleas were given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Powers to plead guilty?
No, Your Honor.
no, Your Honor.
Mr. Powers, other than as we've discussed on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, sir.
Is it your own choice to plead no contest today?
Yes, sir.
All right, how are we establishing the factual basis?
I'm not sure how to, if you'd like, I don't know. I have a police report, but I'm not sure how the court would be able to utilize that.
Your Honor, if the court wants, I can put the factual basis on the record.
Fine.
Your Honor, reading from Lenawee County Sheriff's Report 210005128, authored by Lenawee County Sheriff's Deputy Zach Wobrock. Had this matter proceeded to trial, people would have proven beyond a reasonable doubt that on or about June 6th of 2021, in Dover Township, County of Lenawee, State of Michigan, Deputy Wobrock and Deputy Howard had responded to a complaint regarding UDAA, the stolen vehicle in question being a 2004 Harley Davidson motorcycle. While they were not able to locate that motorcycle at that time, eventually they did come into contact with that motorcycle. They were in a marked police car at that time. They did attempt to initiate a traffic stop on that motorcycle. When they did, the driver of that motorcycle, being David Powers, did speed away from them in an attempt to elude the stop. He was given a signal both visually and audibly by the officers. Again, they were in an official vehicle. Your Honor, I believe that satisfies the elements for the fleeing and eluding. As far as the malicious destruction of property, Your Honor, the vehicle in question was not recovered on June 6th when the fleeing and eluding occurred. It was found at a later date, I believe, on, hang on, Your Honor, I apologize, it's a few different reports I'm you have to get myself through. Let's see. Your Honor, on June 14th of 2021, a Detective Ward with an Ohio law enforcement agency did contact Deputy Wobrock because they had found the stolen motorcycle. At that time, there was some pretty severe damage done to the motorcycle. That was done without the permission of the registered owner. The estimate that was conducted for the repairs to the bike came to $2,959.29. There was also a payment that had to be made in order to get the motorcycle out of impound of $244.54. And a towing fee of $100 because the motorcycle was not drivable. Your Honor, given that recitation, I believe that does satisfy the malicious destruction of property elements as well.
Mr. Linton, do you agree that the elements of both offenses are satisfied?
I do, Your Honor.
All right. Has the court complied with MCR 6.302 B, C, and D, Mr. Bayonet?
It has, Your Honor.
Mr. Linton?
Yes, Your Honor.
I will accept the pleas then. They have been given voluntarily, understandably, and accurately. Mr. Powers has had full knowledge of his rights and he's had competent counsel. Of course, not made any agreement regarding the possibility of a plea or possible sentence in the case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer the matter to the probation department for a pre-sentence investigation, and we will set sentencing for May 16th at 8:15 a.m.
Judge, would this be a district court matter?
No, the attempted fleeing and eluding is a 2 year, so I think that would make it. that's a felony, so that would make it a MDOC.
Actually, Your Honor, the attempted fleeing and eluding should make it a 1 year. I'm looking at the information right now, and I realize that that penalty was never corrected. So I can get an amended, a second amended to the court reflecting the correct penalty, but it should be a misdemeanor 1 year.
All right, so yeah,
penalty.
then it will be a district court matter. So it will be referred to the district court probation office. We'll still set sentencing for May 16th at 8:15 a.m. And so I guess I'm still a little confused on Mr. Powers' status with the Ohio facility where he is. Is he being held there just because of this case?
Yes, Your Honor. While this case is open and pending, they've indicated they will not release him until it's concluded.
So logistically, Your Honor, how would we go about getting a pre-sentence investigation on this case? Because typically we would have somebody go to the probation department.
And I'm sure you're aware, we attempted to get his PSI from Ohio up and down every way possible, and they actually went to court and got a court order saying that they don't have to turn it over. So
All right, so Mr. Linton, what I'll ask you to do is contact Mike Karen in the district court probation office and work with him to make arrangements to get that interview done.
okay, I will do that.
And then he'll be able to do a report and be able to get the sentencing completed.
Okay, yes, Your Honor.
Okay, anything else we need to address for today?
No, Your Honor.
No, Your Honor, thank you.
Okay, thank you then, Mr. Powers. You can let the officer with you know that you are done with the court for today.
Okay, thank you, Your Honor.
Thank you.
Okay, the gentleman at the Lenawee County Jail, are you Mr. Bussing?
Yes.
Okay, Mr. Daly, do you need a breakout session with Mr. Bussing? You were muted, Mr. Daly.
Sorry, Judge. No, I don't need a breakout room.
Okay. All right, we are on the record in file 24-21728-FH, People versus Harley Victor Bussing Jr. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
James Daly on behalf of the defendant.
And Mr. Daly, where do we stand with Mr. Bussing's case today?
Mr. Bussing, we have been trying to get cleared for ET court. The request was filed on March 18th, and we haven't received a response yet.
All right, Mr. Bayoneto, anything to address from the people's side?
No, Your Honor. I think we have a plea worked out. I think it's just a matter of determining whether or not he's going to be accepted into ET court.
All right. Why don't we adjourn it till next week, April 17th at 8:15? And I'll see if I can find out what the status is with the, you said drug court, Mr. Daly?
ET court.
Oh,
Your
I'm
Honor,
sorry.
I think the original intent was for him to enter drug court, but Ms. Teskey believed ET court would be a better fit for him, which is why we're now trying to go that route.
All right, so why don't we adjourn it to next week, April 17th at 8:15. Mr. Daly, would you be willing to do a stipulation in order for that adjournment?
Yes, Your Honor.
Okay, is there anything else we need to address today?
No, Your Honor.
All right, thank you, Mr. Bussing. You can let the officer that's with you know that you are done with court for today.
All right, thank you.
All right, I have someone here logged in. Your screen name is just iPhone. I'm going to send you a request to unmute your device. All right, so I have someone here logged in as Jacqueline Tate. Can you tell me what case you are here for? So the person that just logged in and is wearing a hood, can you tell me your name? Yes, you, sir, looking at your camera. What's your name?
Cody Felton.
I'm sorry?
Cody Felton.
Okay, Mr. Dagger-Margosian, you need to speak to Mr. Felton.
No, Your Honor.
All right, we are on the record in file 23-21654-FH, People versus Cody James Felton. We are here today for a pretrial hearing. In this case, we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
Honor Michael Dagger-Margosian for Mr. Felton.
All right, and Mr. Dagger-Margosian, where do we stand with Mr. Felton's case today?
Your Honor, Mr. Sneed and I had worked out a resolution to where if a certain amount of money is acquired and paid for restitution, that this case was a resolution based on that. Mr. Felton is still working on getting that amount together. So I would ask the court for an adjournment of maybe 8 weeks or so.
I'm sorry, I missed how many weeks?
8 weeks would be my request.
Mr. Bayonetto, anything people would like to address?
No, Your Honor.
So 8 weeks would be June 5th. So we'll set it for June 5th at 8:15. Mr. Dagger-Margosian, would you do a stip in order for that adjournment, please?
Yes, Your Honor.
Okay, so Mr. Felton, your next date to log in is June 5th at 8:15 a.m. The Zoom information is all the same that you used today.
Yes, sir.
So you're all set. You can go ahead and log out.
Thank you.
Okay, Mr. Goldstein, I have Mr. Crone moving over from the waiting room right now.
Mr. Krong, if you can hear us, your camera is not on.
He does not have his audio connected yet. I'm just sending him a chat message with instructions on how to do that.
Okay.
Going down and setting.
Okay, Mr. Crone has dropped out of the meeting, it looks like.
Hopefully he's trying to reconnect.
Oh, yeah, there he is. Oh, all right. Mr. Crone, can you hear me?
Yes, sir, I can.
Okay. So we are on the record in file 23-21520-FH and 24-21715-FH, People versus Jason Ansel Crone. We are here today for pretrial conferences in both of those cases. We are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Mr. Bayonet.
Alex Bayoneto for the people.
David I. Goldstein appearing on behalf of the defendant.
All right, and Mr. Goldstein, where do we stand with Mr. Crone's cases today?
Your Honor, I think these matters can be resolved. We were sort of holding off because Mr. Crone has been in rehab. He has now completed the inpatient portion at Dawn Farms. He is now in transitional housing and has maintained his sobriety up to this point. So I think now would be a good opportunity for Mr. Bayoneto, if these are his cases, to come to some kind of final resolution.
These are, one is Mr. Sneed's and one's Ms. McClure's. So if you want to get together with them for a global resolution, that's fine. I think as of right now, the offer is pleaded count 2 in both files.
Okay. All right. I will talk to them and firm that up. If we could have about a week or so, Your Honor.
Okay, so yeah, we can do a week and do April 17th at 8:15.
Yeah, that'd be fine, Your Honor.
And Mr. Goldstein, would you do a stip in order for that adjournment?
I sure will.
Okay. All right, so Mr. Crone, you'll need to log back in next week, week from today at 8:15. You'll use all the same Zoom information that you used to log in today.
Okay, thank you, sir.
Thank you. You can go ahead and log out.
Okay, have a good day.
Alex, I'll sign your name if that's okay with you.
It is, thank you.
Okay.
I have someone logged in whose camera is off and the screen name is simply iPhone. I need you to unmute your device and tell me who you are.
Jason Lindsay.
Okay. Mr. Lindsay, your attorney is not logged in yet, so I'm going to put you back in the waiting room after I change your name so I can keep track of who's who. And as soon as Mr. Malero gets logged in, I will bring you back in and we'll start your hearing.
All right, thank you.